When the Supreme Court decided Marbury versus Madison in 1803, it did not simply resolve a dispute over a judicial commission, it quietly reshaped the constitutional order. What was presented as a modest act of logic, the claim that judges must disregard unconstitutional statutes, slowly matured into a claim far more sweeping, that the Supreme Court alone may declare the meaning of the Constitution. This shift did not occur all at once, it unfolded across generations, through routines and assumptions that seemed harmless at the time, but ultimately transformed the structure of American government. The earliest example of this shift is found in the case itself. Marshall's opinion announced for the first time that a federal statute could be dismissed as repugnant to the Constitution. Nothing in the text granted this authority, yet the court asserted it as inherent in the judicial function. For decades, the court rarely used this power, but the seed had been planted. If Congress wrote unconstitutional laws, the court would correct them. Over time, this logic encouraged a subtle but consequential drift. Legislators grew less attentive to constitutional limits because the judiciary would be the final guardian of those limits. Courts, in turn, grew more involved in filling gaps and reconciling contradictions. Each corrective act pulled the judiciary a little deeper into policymaking. What started as a brake gradually became part of the steering mechanism. Examples appeared throughout the 19th century. When the court invalidated the income tax in the Pollock decision of 1895, Congress did not revisit its own reasoning. Instead, it sought relief through the amendment process. The message was clear: constitutional judgment belonged to the court. And if the political branches disagreed, their remedy lay outside themselves. By the Reconstruction era, this habit had hardened into a pattern. Congress and the presidency frequently deferred to the court to resolve constitutional disputes about the very amendments they had crafted. When the court narrowed the reach of those amendments in cases like Slaughterhouse and Crookshank, the political branches accepted these decisions with little protest, thereby teaching the public that constitutional meaning ultimately came from the judiciary. The New Deal crisis showed the same dynamic on a larger scale. Roosevelt initially challenged the court's dominance, but the political battle that followed ended not with a limitation of judicial authority, but with its confirmation. When the court adopted a more deferential posture toward economic regulation, Roosevelt accepted the arrangement, and in doing so reinforced the deeper premise that the court's interpretive authority was final. The pattern repeated again and again: conflict, deference, resolution, and a further concentration of constitutional power in the judiciary. As the 20th century advanced, this authority became self-legitimating through precedent. Entire domains of constitutional law emerged not from explicit text, but from judicial reasoning. Free speech doctrine, criminal procedure rules, privacy rights. Over time, precedent accumulated, and the nation came to believe that this was how a constitutional system was meant to function. The Supreme Court became the central arena for resolving the most contested issues of public life. The underlying assumption that the judiciary alone speaks with constitutional finality solidified without ever being submitted to democratic approval. Historical examples confirm how far this shift carried the court. In McCulloch versus Maryland, a straightforward dispute about state taxation became the foundation for expansive federal authority and implied powers, announced not by Congress but by the court. In Cooper v. Aaron, the court articulated its most audacious claim, that its interpretations of the Constitution were themselves the supreme law of the land. This was not what the Supremacy Clause says, but it became the doctrine that shaped the next half-century of American governance. Once judicial supremacy was assumed, the political branches began to act accordingly. Congress delegated vast regulatory authority to administrative agencies and relied on courts to police the boundaries of that delegation. It passed sweeping or aspirational statutes and left the judiciary to refine, narrow, or reconcile them. Presidents waged military actions without formal declarations of war, leaving constitutional objections to be sorted out in lawsuits that courts often dismissed as political questions. Each step drew more authority into judicial hands, not because the judiciary demanded it, but because the elected branches abdicated it. By late in the 20th century, this pattern had become cultural. Law schools taught that constitutional meaning emerges chiefly from judicial opinions. Citizens came to view courts as the principal interpreters of foundational questions. The idea that legislators or presidents bear independent responsibility for interpreting the Constitution, the idea once so familiar to Jefferson, Jackson, and Lincoln, had become all but forgotten. A system once defined by departmental balance now revolved around a single interpretive center. This transformation had predictable effects. Congress no longer drafted statutes with the precision the Constitution once required. Instead, it produced sprawling bills whose ambiguities courts were expected to interpret into coherence. The judiciary, compelled to solve problems created by legislative drift, stepped deeper into policymaking. Each intervention justified the next. The very sloppiness encouraged by judicial supremacy made judicial supremacy appear unavoidable. What began as an opportunistic assertion in 1803 became an irreversible structural fact by the dawn of the 21st century. And yet, even after 2 centuries, one fact remains unavoidable. The American people have never explicitly consented to judicial supremacy. No amendment ratified it, no convention debated it, no referendum endorsed it. The system rests not on written authority but on habit. Continuity has often been mistaken for legitimacy, and precedent for popular sovereignty. If the shift that Marbury initiated is to be reassessed, then the process must begin where the Constitution itself began, in the states. The states existed before the federal government, and their consent is what created it. They continue to possess judicial systems established by their own constitutions and accountable to their own citizens. Nothing in the federal Constitution actually requires those courts to treat the Supreme Court's interpretations as binding commands. The Supremacy Clause makes the Constitution supreme, not the judicial opinions of any court. A state Supreme Court, when faced with a federal question, could simply declare that it respects the reasoning of the United States Supreme Court, but is bound by its own oath to the Constitution itself. Such a court would not be defying the Union, it would actually be fulfilling the precise duty federal judges claim for themselves, the duty to interpret the Constitution. If even one state took this step, a dormant constitutional dialogue would reopen. If several states did, the nation would be compelled to confront a question the founders intentionally left unresolved: whether constitutional uniformity is preferable to interpretive independence, and who gets to decide that question. The answer would not come from the judiciary, for the judiciary cannot define its own supremacy. It would come either through national acquiescence, a quiet, peaceful rebalancing, or through a constitutional convention, in which the people themselves decide how constitutional meaning ought to be allocated among the branches in the states. Either path would be constitutional, neither requires confrontation. Both require only a simple recognition that the Constitution belongs to the people who ratified it, and to the states that form the Union, not to any single institution that has come to speak for it by default. A republic is sustained not by precedent, but by consent. To remember the distinction is not to rebel against the constitutional order, it is to reclaim the balance that once defined it and to restore the sovereignty from which it arose. If the states are to reclaim the interpretive dignity they once held, if they are to resume their rightful role as co-guardians of the Constitution, then conversation alone is not enough. The judiciary of your state exists to serve its people, and its justices can only uphold the Constitution as they understand it. They deserve to hear from citizens who believe that constitutional interpretation is a shared responsibility, not a monopoly of any single court. That is why I encourage you to take the next step, to write the members of your own state Supreme Court. You will find with this video a simple form letter that you may use as a foundation. Personalize it, refine it, or rewrite it entirely. What matters is that your voice reaches those who have sworn the same oath to the Constitution that federal judges swear, and who retain every right and every duty to interpret that document independently. If even a handful of states begin this conversation, the balance of our constitutional order can shift, peacefully and lawfully, toward the pluralism the founders envisioned. Every rebalancing begins with a single act of remembrance. It is time for action. Let your voice be yours.